Metropolitan and Local Councils must meet by the 23rd of November to elect office bearers, but with some coalition talks stalling, what's next should parties not reach an agreement? Gauteng Kokda, head of legal services, Advocate Quinton Kuhn, joins us now to talk about this and more. You're a part of this conversation, as I mentioned. What's your prediction? What will happen? Will political maturity prevail, or are we likely to see a derailed council meeting and delayed election of mayors? 072-110-5584 or tweet us tonight at Newzroom 405. Advocate Kuhn, good evening and thank you very much for your time. It's not there. I mean, what is your take on the instability of these power sharing arrangements? Is governance in various municipalities in Gauteng likely to be under threat?
Hi, Tawa. Thank you and for having me on your show, and good evening to your viewers. I think it's a very important question you ask, but it's also a very difficult question because one cannot necessarily foresee what will transpire in these council meetings. But as you well know, we do have some sort of experience from the 2016 local government elections, where we did not have any party that had won an outright majority in that elections, particularly in Tshwane and Joburg, Ekurhuleni. Whereas Ekurhuleni, one can confidently say it was very, very stable. But as we know, and not to go back into the history of the other two municipalities, it is a cause of concern, yes, in terms of where a party has not won an outright majority. It can definitely lead to unstableness. But I think in our statement this afternoon, it was very clear where the focus should be. And the whole statement, the issue of putting the citizen first, it permeates throughout the whole statement that was issued today. And that is where we want to appeal to all councillors, our councillors, when they go into council meetings, to have that uppermost in their minds. Yeah. What is the important issue? The issue is efficient and effective service delivery provision to the citizens.
Yeah, it's precisely that experience that we know from 2016 that leads to the next question, to say, as province, how do you plan to deal with political pettiness that we have seen play out in 2016? In fact, we have seen already play out in different municipalities, for example, in KwaZulu-Natal, which sought to derail the meeting of council and delay the mayoral election. How do you plan to deal with that political pettiness?
Yeah, thank you, Thabo. Yeah, look, as I said, we are very well alive to such an eventuality if they do arise. However, the stance that we have taken, in fact, is that we are guided by the Constitution as the supreme law, although, and I think maybe importantly, what I must first raise, is that the law is very clear to a certain extent in terms of what must transpire after the results has been declared by the IEC. We now know that the results were declared on the 8th or the 9th of this month, November, and the Structures Act, as particular Section 29, subsection 2, dictates then councils must convene within 14 days from that date, which means the expiry date is the 23rd. For them to convene and constitute council. So we know that. However, I think it's a very good question that you ask. In the event, basically, that they don't convene or they do convene, but they don't elect the office bearers, what happens then? And in that respect, when we survey the applicable legislation, the legislation is silent on what must happen on that. However, there's an obligation on municipal councils that is placed on them by the Constitution to say they are responsible for executive and legislative obligations in terms of Section 152, which sets out the objects of local government, issue of good governance, issues of provision of basic service delivery, etc., etc. So, of course, if you don't have a council constituted, you don't have office bearers installed, it means you don't have a government at local government level, and therefore service delivery can be compromised. Then the Constitution will direct the relevant authority, in this respect it's the province, to say what steps needs to be taken. And I know in the uppermost minds of some is to think of 139, the solution of municipal council. No, that is not the way one should look at it. That is the ultimate last step. The first type of steps maybe to consider is intergovernmental relations and cooperate municipalities in the spirit of cooperative governance as embedded in Chapter 3 of the Constitution. So there will be that type of processes that will unfold, continuous engagement, support that will be provided by the provincial government to ensure that municipalities ultimately convene and elect the office bearers so that the government is constituted at local level.
So what powers do they have? I mean, your statement says we will deploy senior managers to all municipalities in the province to observe and give support to municipal councils. What powers do these senior managers have? What effect will their observation play, and what support can they really give?
Well, basically also, we are actually compelled to monitor support in terms of Section 154, and 154 also then say we must monitor and support municipalities. Now, as I indicated, we know these municipal councils, they are fragile because of the nature of the outcome of the elections. They are hung councils. So anything can happen, and we have to be ready for that. So the senior managers are deployed, they are on the ground, they will have a blow-by-blow account on what has transpired, prepare the necessary reports, and what is their findings, and make recommendations to the provincial government through the MEC, who will obviously also engage with the provincial executive council. But for now, we must also say we will operate within the confines of the law. As matters stand now, it is in the hands of the municipalities and the municipal managers to ensure to convene that first meeting, to preside at that meeting until the speaker is elected, so that the council can continue with its business. But as I indicated, at some point when there is a stability that has cropped up and matters deteriorate, then the provincial government, as I indicated, will be guided by the Constitution.
Now, previously when, of course, chaos ensued in Tshwane and province had to intervene, you indicated that the department would seek to engage with the National Parliament, National Council of Provinces, to seek legislation that governs coalitions going forward. Now, what will the future look like without, as you've already mentioned, I mean, our legislation is quite quiet on that, without national legislation that governs coalitions? And if indeed we ought to seek that kind of legislation, what would it look like?
Once again, I think it still requires some more meaningful engagement on that matter, from a policy perspective, to ultimately come up with a piece of enabling legislation that will deal with all the issues based on the experience of hung councils. So at this point in time, we might not have the definitive answers to that question. But as I said, it will require engagement with all stakeholders involved in local government. Of course, the citizens is important, but they must have a say and a pertinent say in the type of legislation that must come up to ensure that there's once and for all stableness at local level. So for now, I think this, yes, I'm well aware that I think the MEC was just in office when this matter was raised, in terms of looking at maybe possible legislative changes to the current system of governance.
All right, let's continue with Advocate Quinton Kuhn in a moment. He's the head of legal services at the Corporate Governance and Traditional Affairs Department in Gauteng. This, as of course, councils are set to meet for the very first time. What's your prediction on what will happen? Will political maturity prevail? Of course, and the ability to govern across divisions will be something that will be exhibited by the opposition political parties who are for.
Coalition arrangements and political agreements, along with the compromise and cooperation they require, are a normal part of everyday politics in many parts of the democratic world. What should be of importance within the current political realities that we are faced with is the following: safeguarding of citizens' interest within these arrangements, ensuring that the constitutional obligations of municipalities as embedded in Section 152 of the Constitution are not compromised through these arrangements. Institutional stability and sound governance is not thrown out of the window for the sake of political expediency. This can be partly achieved through enhancing the transparency and accountability of coalition arrangements by public disclosure of coalition arrangements in order to ensure that society can hold the various parties to account, a kind of contract with the people that can be easily monitored. Coalition partners can set out clear dispute resolution mechanisms so that coalitions are not prone to falling victims to the whims and moods of political parties at the expense of governance and stability within municipalities.
All right, let's continue now. Advocate Quinton Kuhn with us, Head of Legal Services at the Gauteng COCTA. Right there, Advocate, to safeguard the interest of the residents, how do we in practical terms begin to enhance that transparency and accountability of these coalition arrangements? As the MEC puts it, some kind of a contract of the people and the parties that can be easily monitored. So one would ask then, who, for example, would govern this contract? Who would look after it? Who is impartial enough to be able to say, well, here's a contract, I'll look at the legalities of it and the soundness of it, and this is how people can monitor it?
Yeah, look, just to start from the last point, maybe the enforcement of that is also another issue that one has to look at and perhaps come up with some type of legislation to deal with that. I think perhaps once again, we will always go back to the experience of 2016 in terms of one, I don't know, one can call it, but there are coalition arrangements, coalition agreements, coalition contracts. We don't know that. But as I said, we have learned from that experience. Or when I say we, I hope, and I'm not, and I hope I'm not running the risk of entering a political terrain because I'm an administrator. But this time around, what we say, the urge and the appeal is that those, if in the end there is indeed coalition arrangements or agreements, it must at least be embedded in some kind of black and white written form or document. And importantly, I think, is to make it transparent, to publicize it so that the citizens, the communities can know exactly to what these parties have agreed to. And I think it's up upon the citizens then to hold those parties to those agreements accountable.
Yeah. And do you think that the South African local government system, that is the executive mayor system, is designed for power sharing?
Well, first and foremost, mayoral executive system, it is, it's a first past the post, 50+1. If you win, it's then the prerogative of the mayor to appoint his or her mayoral committee. It does not say if the mayor is from party A, the mayor has to choose members of the mayoral committees from that party alone. The mayor can choose from any other councillor. And I think in some of these type of arrangements, if you look at the former government of local unity that was installed in the city of Johannesburg, there were councillors from other parties who occupied portfolios as members of mayoral committees. But that is clearly the prerogative of the executive mayor to constitute his or her mayoral committee as he or she deems fit.
Yeah, it's precisely that why I'm asking that question. The concentration of power on the executive mayor, because, I mean, as you put it, the mayor can literally bypass council. He doesn't need council to set up his committee. He can appoint whom he wants and fire whom he wants, quite honestly, without council actually coming in there. So is that system designed for power sharing arrangements as the ones that we are seeing coming?
Well, again, the simple answer is if it is up to the mayor to, if he or she wants to have a type of power sharing within that system of the mayoral executive system. Unless, and I don't know if you might be aware, there is another system, another type, is called the collective executive system, and that is by legislation that compels that parties will be represented in that executive committee proportional to the percentage of votes they have received in election.
Yeah. Do we have that kind of a system in South Africa, PR system?
The collective executive system in Gauteng, definitely we don't have that system. Currently, we have a mayoral executive system. I believe in other provinces, they perhaps do have that type of system. But the law does allow the MEC to change the current system or change any type of system. For example, as I indicated, we have a mayoral executive system, and the MEC has the powers in terms of the Structures Act to change the system to collective executive system, where you have, well, by operation of law, all parties, based on the number of votes they have received in an election, or the percentage of representation in the council to be proportionately represented in that collective executive system. But then the mayor of that collective executive system must be elected by the council still. So you can still have type of a challenge when you go, if it's a hung council, and for the election of the office for a mayor for a collective executive system.
Yeah.
But that, as far as we know, that is the legislation cater for such a system where there is power, what you could call power sharing by operation of law.
Now, I mean, by and large, council in many of the metros in Gauteng really just plays an oversight role where mayors can be able to sideline council. But for the sake of more accountability, right? Would municipalities, metros in particular, benefit more from having at least some power rested within council to be able to hold mayors accountable? And not only that, for example, in our system, there is no clear line around political party and the role of council, right? Because, for example, political parties can recall their mayor anytime without seeking a word from council. Does that kind of structure need some tweaking, some concrete legal framework to be put in place to deal with that?
Yeah. Now, look, I don't think there's one can say that an executive mayor can bypass council. If I can just make a distinction, if you look at the issue of separation of powers at the provincial and national legislatures, where the legislative responsibility will vest in Parliament and the provincial legislatures respectively, and the executive responsibilities will vest with Cabinet at national level, and then with the Provincial Executive Committee, the Premier and the NEC will have executive responsibilities. However, at the local government level, you will have municipal councils, in terms of the constitution, have executive and legislative responsibility. And maybe that is also an issue one will have to look to make a clear distinction, as is the case at the other two spheres of government. But nevertheless, notwithstanding that, the municipal councils still have an oversight role to play over the mayor and the mayoral committee. So there is checks and balances in place. So it's up to the council itself to hold the mayor and his committee or her committee accountable. You see. Yeah. Because by the very nature that the municipal council has executive and legislative of the powers in function.
Right. By way of again, just finding out how do we safeguard service delivery and good governance. Do we have legal structures in place, for example, that safeguard citizens from volatile political coalitions? So, for example, whether it be inter-party conflict where the situation is unsavory, or it be intra-party conflict, that would safeguard that when that happens, those interests of the party or those interests of the individual do not take prominence, but rather good governance and service delivery becomes prioritized.
Look, my response to that is in terms there is accountability mechanisms in place. For example, if you talk specifically about councillors, there's the code of conduct, which regulates how councillors should conduct themselves. That is not in relation to individual councillors, but as a council as a whole. The other legislative instruments, as we know, there is what, and I think by now everyone would be familiar with the Section 139 powers of province and even national government. So I think is the legislative instruments are there. It depends. It all depends on terms of how you apply them, how you invoke them to ensure that the interests of citizens are safeguarded. Yeah. But if it is not sufficient, then again, it's a matter that one can delve into deeper to see how can you strengthen it to ensure that there is ultimately stable local government.
Now, while we're there, I mean, we have, for example, as you speak of the code of conduct of councillors, maybe even a code of conduct of mayors, right? We had a case, for example, in Tshwane of some impropriety that happened in offices, right? And they invoked the code of conduct. But you have a mayor now in Kanaland, I think that's what it's called in the Western Cape, who has issues around gender-based violence. Is there a code of conduct that prevents such councillors or such individuals from participating?
Yeah, not so fair. And this is also, it's a very complex issue. And, and sometimes when you want to deal with ethical issues, and sometimes it's difficult to regulate or have laws in place to deal with the ethics and moralities type of. But I think in the entrance of the code of conduct, just after its preamble, there's what we call item 2. It clearly says how councillors should conduct them. And I think that and it underscores at all times. So it doesn't really mean just from 9 to 5. This is how you should behave whilst you're in council. It says at all times as a councillor, because you're a public representative. You see, so whatever you do outside of council, and it has the potential or the ability to compromise the integrity of the council, then surely, I think, in my view at least, is that the code allows a council to probe deeper into that type of conduct.
And let's talk then about what the MEC also raised around questions of dispute resolution. Do we have mechanisms in place by which we can ensure that parties they follow a certain formal structure or procedural safeguards that are in place should an unpleasant situation arise, should a dispute arise amongst the coalition partners?
Well, I think, as I said in the beginning or so, currently there's no legislative instrument available to regulate coalition arrangement that is not in place, or even now the question you've raised to deal with some type of disputes between political parties, and perhaps what they can factor in if they come up with a coalition agreements, to factor in those type of dispute mechanisms as political parties. Remember, our focus is not to monitor and support political parties and have oversight over political parties. Our focus and our constitutional responsibility is to monitor, support, and when necessary to intervene in municipalities as a whole, irrespective who is represented in that municipality. But if things go wrong, then we'll have to exercise our constitutional responsibilities in a manner that is consistent with the legislation.
All right, let's take your thoughts, 072-110-5584 when we come back from the break. Plus, we'll hear from Advocate Kuhn what are the more concrete legal steps, for example, that they are taking towards professionalizing civil service, but also what do they expect will happen at the first meeting in Sedibeng and Mfuleni, where already we are seeing some kind of tensions there around the first seating. That's the Gauteng Cocked Head of Legal Advice, Advocate Quinton Kuhn, staying with us, and of course taking your WhatsApp messages. Stay with us.
It has, however, come to our attention that the erstwhile executive mayors of Sedibeng and Mfuleni bona fide appointed acting municipal managers without obtaining council approval as required by the provisions of 82 subsection 1 subsection B of the Structures Act. This means that the appointees in question have no legal standing to preside over the first meeting of the new municipal councils of Sedibeng and Mfuleni. In the circumstances, we've decided to invoke the powers vested in us by Section 29, subsection 2 of the Structures Act, as alluded to above, and accordingly designated Mr. Mponawa, an eminent local government practitioner, to preside over the first meetings of the new municipal councils of Sedibeng and Mfuleni. The executive manager of Sedibeng and Mfuleni have been advised to provide the necessary support to Mr. Nawa in order to ensure that the first council meetings are a success.
Welcome back. Thanks for staying on. Of course, we'll take some of your questions tonight for the head of legal services, Advocate Quinton Kuhn. But Advocate, just explain that for us. What transpired here? What has led to this confusion that those who had no legal standing would want to preside over those council meetings?
I think, look, in that respect, the law is at least very clear. Section 29, subsection 2 says the first meeting must be called and presided over by a municipal manager. Now, one would ordinarily assume that the status of that municipal manager is not questionable in terms of the law. And as I indicated, I must also make this point, Thabo, even prior to the election, we already have assembled, as I said, senior managers are on the ground via our regional teams to support municipalities in terms of our obligations. We monitor municipalities. So we have worked out some sort of program, a timeline. When you have the election, what is the next step? What will happen? All of those type of things. The results, the elections was on the 1st. The results was declared formally and legally on the 8th. What is the next step in the process? The next step is the municipal managers to call the first meeting, preside over the election of the speaker. So it's like kind of a checklist where we would tick the boxes. That is the basics, but that is important. And throughout that monitoring process, then we have established there might be some issue around the appointments of the two acting municipal managers in Mfuleni and Sedibeng. And because it's the legal responsibility or statutory responsibility of a municipal council that to whenever there's a vacancy or whenever it is necessary to appoint acting municipal managers. Now, in this instance, we found established that the appointments were made by the executive mayor, and we say they were made bona fide because the mayors were genuinely under the impression that they had the powers, either in terms of a delegation or in terms of a policy to make those appointments. Because at the time those appointments were made was during the course of the elections when council was in recess. And the councillors were obviously out to campaign, and in order to fill that vacuum that might arise, precisely for the calling and the presiding of the first meeting, they took the initiative, as I say, bona fide, without any ulterior motives, and appointed officials to act in those positions. We then established, as I said, through our feedback and our monitoring processes, that it might be problematic and you will end up in all sorts of litigation, which we don't want, especially starting a new term of local government. The focus must be on service delivery, not on court cases. Yeah. So in the event that the municipal manager, because basically what has resulted, there's an absence in the office of the municipal manager, that there's no municipal manager, there's no acting municipal manager. The law then compels the MEC to designate a person to go in the stead of the municipal manager and call and preside over the first meeting. So that is precisely what it has now transpired.
Yeah. Do you envisage that particular selection of a caretaker in that position as appointed by the MEC would create some kind of tensions? I mean, you are essentially putting an individual there who was the administrator in Tshwane, and for example, the Democratic Alliance mayor has accused him of having plowed billions in Tshwane and misspending close to 4.4 billion, according to them, in carrying a deficit in just 3 months. I mean, is this something that you don't see that's going to be challenged by those who are in that council?
Well, I suppose anyone can challenge anything. Everyone has the good right to challenge or go to court if he or she thinks fit. But when we look at, obviously, we just not willy-nilly make appointments or designate persons to undertake a particular task. We look at the suitability and the competency and the skills for a person that can handle a particular task. And as we indicated, Mr. Nawa is an eminent local government practitioner, vast experience in terms of how to handle particular type of situation. And that basis, based on the suitability and competencies and skills, the MEC applied his mind properly and decided to designate Mr. Nawa to go and preside at those meetings in those councils. Yes, we are aware about the other that what we want to call accusations, allegations about plundering billions of that, but so far we have not received any formal report. We have not heard about any investigation, any criminal cases that has been opened. So it is very difficult for us to respond in that respect. But as far as we're concerned, we have the MEC has make a proper decision, and we believe the trust that the MEC placed upon the designated person will potentially yield the desired result. What we want is ultimately a stable municipal council in those municipal councils and all the councils in Gauteng.
Yeah. Purely not from a political point of view, Advocate Kunt, but from an administrative point of view, because you're an administrator. If we look at putting particular individuals to do particular functions, I mean, it has become quite an expectation in this administration of the current president that you would want to put people who don't have a dark cloud kind of hanging around them, that have been cleared, that don't have question marks around them. And is it something that the MEC would have considered quite deeply here, considering these allegations and have not been properly addressed and cleared?
Yeah. Look, as you rightly pointed out, that is allegations, and I think if the MEC each and every time has to take an executive decision to see there's a dark cloud of who, and as I said, then there's a lack of substance in the allegations or the reporting of the relevant authorities, it becomes difficult because every time you place someone in a particular responsibility, at the end of the day, you might not have anyone to put in a particular responsibility. So no, we are not guided by this. As I said, the decisions the MEC made is after consulting, after properly applying his mind. And I must say, there's not only one name that's normally placed before the MEC when these type of decisions are made. There's a list of eminent persons with particular skills that is presented to the MEC with excellent and eminent resumes, and from that the MEC is advised to take a proper decision objectively.
Yeah. So, for example, when the administrator presented the report to council in Tshwane, one of the parties called for example, that report to be taken to public accounts, to be analyzed and audited, for example. Has that process been done and the 4.4 billion accounted for and everything cleared?
Well, I have no information on that, so I won't be competent to respond to that question.
All right. Let's then talk about what are some of the more concrete legal steps that the province has taken, maybe in assisting municipalities towards professionalizing civil service.
Yeah. I don't know if you can recall at some point in 2011, and it's not necessarily the province, you'll also know that local government is it's mainly regulated by national legislation. But nevertheless, in 2011, there was these amendments to the Municipal Systems Act to precisely deal with the professionalization of local government. Unfortunately, I think SAMU challenged the act, the constitutionality, and based on a technicality, the tagging, what they call the tagging, it was supposed to be a bill that would have via the provinces for some other reasons. And on that score, it was declared constitutionally invalid, and the Constitution allowed Parliament 2 years to rectify that defect. The deadline was unfortunately missed, but it is again in the pipeline. And the latest that we have checked, I think, is for the NCOP. They have approved or adopted the bill. It should go to the Honorable President for assenting and publication in the Government Gazette. So that is one of the main objectives of that particular piece of legislation, is to surely realize the objective of a professional type of service at local government. So there is a legislative instrument that is coming again to deal with it.
All right. Talking of legislative instrument, I would want to find out how you got to this decision, which the MEC announced earlier on councillors who are not returning into office. Let's watch what the MEC said earlier on that question.
As part of our constitutional obligations and dictated by Section 154 of the Constitution, COGTA will deploy senior managers to all municipalities in the province to observe and give support to municipal councils. Our primary focus is on ensuring that there is a smooth transition into the new term of office within local government in Gauteng. This is important as it will usher in stable local government and create a conducive environment for municipalities to provide quality services, which will in turn improve the quality of life and standard of living of the people of Gauteng. It is common cause that not all councillors who served in the previous term will return to office. This inevitably places them in an untenable financial position. Hence, since the 2011 local government elections, it was deemed appropriate to pay a once-off gratuity to qualifying non-returning councillors that is equivalent of 3 months' salary to assist them to meet already entered into financial commitments.
Advocate, I don't know whether that's a legal term, deemed appropriate, or is it just out of goodwill, or is there a legal obligation to do that?
Well, I don't know out of goodwill or what, but I said the policy decision in 2011 is that, councillors, unlike their counterparts at provincial and national, where they've, I think, what I want to call solid pension funds, so to speak, and it was appreciated that councillors that are not returning, they are worse off because, so I think the decision was then taken for at least a period of 3 months to pay a gratuity. And I think, look, we have a dedicated units in our department dealing with those type of financial issues, together with National Treasury, Provincial Treasury, and National COCTA. And I think also we have the Financial and Fiscal Commission, the remuneration of that office, they're dealing with the remuneration of office bearers generally, which make recommendations to the relevant authority in the minister to look at this particular issue. And so that was a considered decision that was taken to at least provide, as I said, a minimum of 3 months salary for non-returning councillors.
Yeah. Was it done by council resolution, or is it, as you're saying, is something that is considered at treasury level?
Well, I think the administrative process is how it will unfold. Look, respective municipalities will have a record of councillors who will not be returning, and at the starting point of processing applications will be at that level through the provincial COCTAs. And from provincial COCTAs working provincial treasuries is to then submit the applications to National Treasury, not National Treasury, to National COCTA, who will make a determination on whether a councillor qualifies or not. Because you might find a councillor, yes, who's been in office, I think, for 5 years. You find the councillor who's in office for 2 or 1 years. So there are predetermined qualifying criteria that is set, and based on that criteria, determination is made on how to arrive at a particular payment. As I said, at the very least, it goes up to at least a 3 months salary as a gratuity.
Yeah, it could be seen as a political question, but also, I mean, it could have administrative implications when you look at the sum total of the money that would be paid. Others would be saying, by and large, councillors who will not be returning could possibly be ANC councillors, but of course there are other parties as well. But a majority would, by and large, be ANC councillors who have lost their seats because of the decline in support. Would this be seen as some kind of dispensing of patronage?
Well, I would not know, and I don't think so. Where we are sitting, we haven't seen any evidence of that. We look at it as councillors, and the criteria does not say from which party you belong in order to be considered for payment.
Advocate, appreciate your time, and thank you very much for joining us. Quick look at some of the WhatsApp messages coming through tonight on this conversation. Adrian in Equestria saying the politicians have forgotten that their personal issues are not for the good of this country, and if they do not find a common ground, they must just pull out and let those who want to work for this country do so voluntarily. And namaste in Open Protea. I think political maturity will prevail. These political parties have been chosen by people to represent them. They have not been voted in to represent their pockets. Gauteng has experience when it comes to coalitions. Let's let Gauteng lead, then the rest of the cities will follow. Coalitions are the way people have spoken. Appreciate your messages, and thank you very much to Advocate Quinton Kuhn as well, helping us to be a part of this conversation.